So my understanding from reviewing things, if my math is incorrect, let me know that it's incorrect. But from what I can see, she was 12. Am I reading this incorrectly?
It's the state's understanding.
Because it's alleged to have happened on or about 2016. And the date of birth is 2004. So she's either 12 or 13.
This case is downright shocking. We're looking at a guy in court for something absolutely vile, and the kicker, he was already out on parole when it happened. That's not a one-off mistake, that's a clear pattern. It isn't even his first time. Honestly, crimes like this should lock someone away for life, no questions asked. The courtroom feels heavy, everyone's silently asking the same thing. How does a man like this keep slipping through? Parole boards are supposed to judge risk before release, but someone clearly dropped the ball here. Should the system itself be held responsible for unleashing repeat offenders back onto the streets? Let's break it down.
Parties announced for the record for the state.
Spanks, the state of Texas.
For the defense. Are you Sean Branch?
Yes, ma'am.
All right. You entered a plea on May 11th to aggravated sexual assault. You entered a plea of guilty. According to the plea bargaining agreement, punishment is to be assessed at a cap of 20 years. The state is opposing your application, and there's to be no contact with the complainant. Have both parties had a chance to review the PSI report, state? Defense? Any objection? All right. Any witnesses?
Just Mr. Branch maybe want to say something to the court, but I have some things to put on the record.
All right, Mr. Branch, if you would like to say anything to the court, you'll be placed under oath, and the state will have a chance to cross-examine you. So do you wish to say anything?
No, ma'am.
All right, thank you. All right. State, you're opposed?
Yes, Your Honor. The reason the state is opposed is this wasn't just a one-time incident. It happened multiple times. There's a confession in this case. When questioned by the detective, Mr. Branch told the detective that the complainant let him know that she had previously would touch him in different ways, and basically that she was coming on to him. The state's argument is that's no excuse. The defendant should have told the complainant that he's an adult and that the way she's acting is not the right way to act with adults, and taken the lead and made her understand the right way that adults should behave around children. Instead of that, the defendant took advantage of the complainant and had sex with her in various ways, placed his hand with his hand, and for that reason, the state is asking for you to sentence the defendant to 20 years TBC.
All right, defense.
Again, those are all reasons why Mr. Branch pled guilty, and guilty as opposed to no contest. He knows he's responsible. He knows what he should have done. He knows what he didn't do that he should have done, and so he pled guilty. The fact is, this man has no prior contact with the justice system. He served 8 years in the U.S. Army, deployed twice to Iraq as infantry and field artillery, and he has no excuse for what he did, which is why he pled guilty. And this is not offering him background as an excuse, but as potential mitigation of punishment, which the law allows. We have ranges of punishment for these things, especially at first degree, 5 to 99 or life, for a reason. And if anybody should maybe qualify for probation in such a case, among other people who may have such a case and worse records or other things in their past, I would think it would be Mr. Branch, simply because he's never had contact with the justice system before. And so we're asking that you give him that chance. Judge, how rigorous, from both your experience as a defense attorney, prosecutor, and judge, how rigorous probation is. It's not a walk in the park by any stretch. And again, other than these incidents, he's got no other issues in the past. So we're hoping that the court might see it that way, but if not, we're asking the court to consider at least imposing something lower than the cap.
All right. So my understanding from reviewing things, if my math is incorrect, let me know that it's incorrect. But from what I can see, she was 12. Am I reading this incorrectly?
It's the state's understanding.
Because it's alleged to have happened on or about 2016. And the date of birth is 2004, so she's either 12 or 13.
Stands to reason that's what made it aggravated as opposed to
Yeah.
the use of force or weapon.
No, I'm just trying to figure out the age. All right, is there anything else?
I don't believe so. Do you have anything else?
Nothing on the scene.
All right, court will find you guilty, and I understand your service to our country, Mr. Branch, and I understand what you're saying happened, and I reviewed everything, and I understand that you did enter your confession to the police, and you pled guilty to the court. The court will find you guilty. The court will sentence you to 20 years in the prison. There's to be no contact with the complainant, Chapter 62 registration, and credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Branch, I will tell you, I do recognize and appreciate the fact that you decided to enter a plea of guilty, the fact that you owned up to what you did, and that you know it was wrong. All right, good luck to you.
Thank you, ma'am.
You're welcome.
I don't care if someone wore a uniform or served their country. Once you commit something this vile, that honor is erased in an instant. Service doesn't excuse destroying lives. Judge Boyd handed down 20 years, and while that's a strong sentence, part of me feels life would have been the only just outcome. Crimes this severe shouldn't even come with the option of parole. What many don't realize is judges can stack sentences for repeat offenders, but in state courts, it rarely happens, and that's exactly how predators keep cycling back through the system. Watching him sit there feels like seeing a wolf pretending to be a house pet. You know it's a mask. This isn't just another trial, it's society drawing the line on what we refuse to tolerate. And in that sense, I think the judge made the right call.
You, Michael Williams?
Yes, ma'am.
All right, you entered a plea of no contest on April 25th. There was sufficient evidence to find you guilty. The court ordered a PSI. According to the plea bargain agreement, there's no application for deferred adjudication. The state opposes your application for community supervision. Punishment is to be assessed at 3 years in the prison. It's run concurrent with County Court Cause number 689077. And they will take in consideration County Court Cause number 699697. And the offense is unlawfully carrying a weapon with a felony conviction. All right, have both parties had a chance to review the PSI report, state?
Yes, sir.
Defense? Any objections to the PSI report, state?
No, no.
Defense?
No, yeah.
All right, state, do you have any witnesses?
No, Your Honor.
Defense, do you have any witnesses?
Yes, I'd like to have the defendant speak, and I would like to speak on his behalf.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Williams.
You're gonna have to speak up.
Michael Williams.
All right, defense?
Okay. Michael, you know that you weren't supposed to be carrying a gun because of a prior conviction?
Yes, sir.
Okay. And what actually happened? You were on your way home from somewhere?
I was on my way home from my aunt's house and I ran into a female friend of mine. It was New Year.
Were you walking from your mother's house or from your aunt's house?
Yes, sir.
Okay. You went into a friend, a lady, a woman?
And she asked me to check her firearm for her because she was getting ready to go. I guess she was going to go sell it.
She's going to what?
I guess she was going to go sell her firearm and she didn't know if it worked or not.
Okay.
So I checked it for her.
So was it loaded already?
Yes.
Okay, so how did you check it then?
I shot it in the air.
You what?
I shot it.
Shot it in the air. Okay, and that was the basis for your arrest?
The base for my arrest was, okay, so she had to leave and go to her parents' home. I was gonna take her firearm to the house for me and hold it for her. So the officer stopped me. Someone had called in and shot. the officer stopped me and told me he got a call, and he got me with unlawful carry.
What do you mean that the police had gotten a call about somebody firing a firearm?
Yes, sir.
Okay. And so he stopped you and you had the gun on you still?
Yes, sir.
From the lady that you had met?
Yes, sir.
Friend? Okay. All right, so you were gonna hold it for her?
Yes, sir. Until she
Okay.
got
All
back
right.
to me.
All right. Yeah, I'd like you to consider this, and from the fact that there wasn't that much malice in his carrying this, it was something that he hadn't expected.
Oh, just 1 second. State, do you have any questions?
Let's see, okay. All right.
State, any questions?
Yes, sir. Is it true that you were on probation for burglary of a vehicle second in the stall?
Yes, sir.
And isn't it also true that you never reported the probation for that offense?
I had complications reporting. I did try to report, but I had problems with my phone and Zoom.
Did you have to go in person?
No, sir. I did call and make an appointment, but I didn't make it.
He says his ex was going to sell a gun she didn't even know worked, so he decided to test it by firing into the air. That's not testing a gun, that's basically begging for a felony and a squad car at your door. And here's the kicker. Under federal law, even a single bullet fired like that can trigger a discharge enhancement, stacking extra years onto your sentence. On top of that, he wasn't even legally allowed to have a gun. Courts don't buy the "I was just checking" excuse. It's reckless endangerment, period. People forget every bullet shot up has to come down, and falling rounds are treated as deadly weapons. Combine illegal possession, reckless discharge, and a paper-thin excuse, and you don't get sympathy, you get years behind bars.
No further mistake.
All right, any further questions, counsel?
And no further questions, I'd just like to speak on his behalf.
Yes.
Okay, Your Honor, I'd like to consider in the PSI where it shows that his upbringing was a problem. He had no help from his father. He was brought up by his aunt and his mother, but he had a lot of psychological problems and depression. And he only went through halfway through school. And then he was not very employable. So for the last 7 years, he'd been unemployed. And I think that idleness also set the scene for his drug addiction and alcohol. But he quit the alcohol in 2014, but he continued on some other drugs, and he hasn't had those in the last 6 months.
All right, just 1 second, counsel. Mr. Williams, I'm going to give you a choice. Here's your choice. I can give you probation, but you're going into inpatient treatment, or either I will sentence you to 2 years in prison. Now, they say that you have mental health issues and that they're recommending MyOff. MyOff is inpatient. Now, you can go to prison for 2 years, do your time, you're done, or either you can be on probation out of this court.
Recommend you for probation.
Well, no, counsel, this is what I would always tell my clients. I'm not the person who's going to be doing probation. He will. And he knows better than I do, better than you, and better than anyone else, whether or not he can successfully complete probation. So far, what I've seen in his history, he cannot complete probation. But I understand that there are mental health issues going on, because in the possession case for his previous conviction, I saw that there was a transfer to MyOff, and then he ended up failing that and ended up going to prison. So you know yourself better than I do, better than your attorney does. Deputy Laura always tells everybody probation in this court is not easy. So your choice is, and there are only two choices. One, I can send you to prison, or two, you're going into inpatient treatment and you're going to MyOff. Either way, you're not going home today. So which do you choose?
I would say, due to my current addiction, I was on heroin. I would say I need an inpatient. I would like to take the probation.
Okay. All right, the court is going to sentence you to 3 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. The UA hotline. We can do a referral to felony drug court. That will be in custody. If he's not accepted in custody, I see here that they're recommending MIOF. That's what they have in there, that he's eligible for MIOF. So if not felony drug court, then MIOF. And then if MIOF is not going to, if felony drug court doesn't accept him and MIOF doesn't accept him, then we'll do SafeP. Proof of employment or SSI within 45 days of release. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month until further notice. 200 hours of community service restitution. Do you have any children?
Yes, ma'am.
What are their ages?
14, 13, 11.
Are you in their life at all?
Not at this time.
That's either yes or no. Have you been an upstanding father in their life? Someone they can look up to?
I have. Not
How?
recently, but I have.
All right. There's going to be parenting classes. This to run concurrent with County Court Cause number 689077. Taking consideration 699697. And then there will be the UA hotline. Counsel, you're hitting the microphone.
Oh, I'm sorry.
The UA hotline until further notice. Probation, is there anything else he needs? Is there anything else you need from me to be successful? I'm sorry?
No, ma'am.
All right. And so the MIOF, the felony drug court, and SafeP, that's to be done in custody.
John, I think he's going to need a lot of help with getting employment. He hasn't had any, and he has his psychological problems as well. So
When's the last time you had employment?
2008.
All right. So you haven't really been supporting your children. All right. And with regards to employment, there's to be no employment as a home health care provider or with minors. If you are planning to be in your children's life and be someone they can be proud of, you're going to have to do better. If you're not going to be in their life on a permanent basis and just breeze in and breeze out, then you need not be around them. You understand? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Mr. Alexander, could you pass that to him? Did you sign that? Did you review that with your attorney and did you understand it?
Yes, sure.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sure.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sure.
All right. Good luck to you.
All right, thank you.
You are.
This is where I just shake my head. His lawyer tried the classic play, blaming a rough childhood and depression, like that somehow cancels out firing an illegal gun while high on hard drugs. Look, his struggles may be real, but court isn't therapy, it's about accountability. And this guy? No job since 2008, not supporting his kids, just repeating the same destructive cycle. What blows my mind is Judge Boyd actually went light, giving him the option of prison or probation. Naturally, he chose probation. But probation isn't a second chance, it's a gamble. One slip, and violations can land you in prison even longer than the original sentence. In a strange way, it's mercy with a built-in trap.